Good morning to all of you. Thank you all for being here. It's remarkable, really, as far as we're concerned, that we're able to assemble such a panel of distinguished experts to deal with public health and administration. You're talking, not just, or will be talking, not just to the audience that you see in front of you, the public and core participants, the press at the back on the left-hand side, but also to legal representatives of various core participant interests who are on the left, and of course Ms. Richards, who is standing and will be asking you the questions. But first, Mary will ask you to take the affirmation.
Please state your full name.
Anne-Marie Farrell.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your full name.
Alison Mary Pollock.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your full name.
David Armstrong.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your full name.
Claire Paddy Salters.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your full name.
Charles Anthony Vincent.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please state your full name.
Michael George Bishop.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Can I start by asking the panel to give a brief outline of your professional backgrounds, starting at the end furthest away from me with you, Lord Bishop.
I began life as a lawyer, spent 20 years in local government, 10 as a chief executive, joined central government in 1990, became a permanent secretary of the Department for Employment and then the Department for Education and Employment, went on to run a university, chaired the CERM inquiry, set up the Institute for Government and chaired the National Audit Office.
Professor Vincent.
I began life as a clinical psychologist working in the NHS, but for the last 30 years or so I've been a researcher, and I've worked on patient safety, which is the study of risk, medical error, and all the sort of aspects of that. And I've worked at University College as a professor of psychology. I spent 10 years working in the Department of Surgery and Cancer, actually in the hospital in Imperial College, and now I'm at Oxford University.
Ms. Salters.
I'm a former senior civil servant. I started life outside the civil service. I'd spent a year working as a locum epidemiologist for a local public health organisation. Then I joined the Northern Ireland Civil Service, initially posted to the Department of Health there. shortly afterwards transferred to the Northern Ireland office and spent most of my career in and around there working on aspects of the Northern Ireland peace process and constitutional arrangements. I spent several years as Deputy Secretary to the Iraq Inquiry and also served as Chief Exec of the Civil Service Commission, where we dealt with the regulation of appointments to the civil service and significantly for the inquiry, dealing with complaints under the Civil Service Code.
Professor Armstrong.
Yes, I've got a background in public health, general practice and sociology. I've spent a lot of my life in research management, that is, giving research grants for medical projects with the MRC and the National Institute of Health Research.
Professor Pollock.
I started off life as a clinical doctor for 4 or 5 years. Then I trained in public health medicine for another 5 years. And for the first 20 years, I had joint appointments between the National Health Service and academia. But for the last 15 to 20 years, I've worked as an honorary consultant for the NHS, Public Health England most recently, in public health medicine. I'm a professor at Newcastle University. But before that, I also had departments that I led at UCL, Edinburgh University and Queen Mary University London.
And Professor Farrell.
Thank you. Born and raised in Melbourne, started life as a lawyer in private practice. I was previously a partner in a law firm undertaking mass tort litigation, mainly representing claimants who'd suffered harm in healthcare settings. I then moved into academia, and I've specialised in health law, policy and bioethics, with a particular interest in human bodies and human tissue and the management of public health risks. And I'm currently Professor of Medical Jurisprudence at Edinburgh Law School.
Thank you. And there are other contributing group members who are described in the report on pagination 101. Now, before we start looking at the report and some of what the issues that you've explored there, it might be sensible just to, in terms of those listening, explain what you weren't asked to do. So you haven't reviewed and were not asked to review the vast amount of evidence which the inquiry holds and has examined over the last 4 years. And so you haven't therefore sought to express views on the factual issues that are for determination by the chair as to whether there were, as a matter of fact, deficiencies in the decision-making processes as regards blood product safety and blood safety. What you've done in your report is identify for us relevant codes and principles, decision-making structures, the different roles of government, NHS, other bodies, patients and patient representative groups, weaknesses or potential weaknesses and concerns in those processes and systems, and offer some suggestions and recommendations for improvement. And so my questions to you will be focused on those issues, and I'll go through the sequence in which they appear in the report. But I thought it might be important to understand for those listening that I won't be asking you to express views on what, as a matter of fact, for example, government did or did not do in the 1970s, 80s or 90s. So I want to start then with the general principles concerning public administration, which you deal with in the first part of your report. And I'm going to direct these questions initially to Lord Bichard, but for others I hope to join in if they have matters to add or agree or disagree with. So in your report, Lord Bichard, you say that the last 25 years has seen the establishment of regulatory mechanisms which have sought to clarify standards of conduct and behaviour that had previously been expected but not formally articulated. And you identify in particular the Ministerial Code, the Nolan Principles, the Civil Service Code. Before we look at those individual codes, but before those codes came into existence and were formalised, by whom was adherence to standards of conduct and behaviour expected?
By whom?
By whom was the adherence to these unwritten standards of behaviour expected?
There wasn't a formal body, for example, the Civil Service Commission, there was an expectation that civil servants and ministers would behave in a particular way. If ministers failed to do that, then they were accountable as ever to Parliament, and Parliament could have a vote of no confidence in a minister. They weren't able to force ministers then or now to resign. Civil servants, the Cabinet Secretary would have had the most important role in terms of ensuring that the conventions, which is what they were followed.
And to what extent was there a good chaps theory of conduct and behaviour in relation to both ministers and civil servants? And a general expectation that people would do the right thing?
There was certainly a general expectation. There was more than that. I think there were, as I say, conventions. When I joined the civil service in 1990, they were spelt out to me, the kind of things that were expected. But I didn't have to sign anything to say that I applied it. I'm not sure I much like the good chaps analogy, although most of them were indeed at the time chaps.
I want to look at, first of all, the Ministerial Code. You've explained in the report it was first published in 1992 by John Major as a document entitled Questions of Procedure for Ministers. What do you know of its origins prior to that?
John Major, I think, published the Questions of Procedure following a number of problems, issues, scandals in the early 1990s. I don't have experience or knowledge of how these were spelt out prior to that. Clearly not as effectively as the Prime Minister wanted, because that's why the scandals arose.
There's a research paper, a House of Commons Library research paper, which I think just gives us a small amount of additional information. So we'll just look at that. Lawrence, could we have RLIT 0001740, please? We can see it's headed Questions of Procedure for Ministers, and it's a research paper from April 1996. And then if we go to page 4, please. I think we can just pick it up in the first paragraph. It says, Questions of Procedure for Ministers was first published in May 1992, although its existence was well known unofficially in the media, academic texts and in Parliament. It was first issued to ministers on a confidential basis by Clement Attlee in 1945, although elements within it are older. The initial versions were primarily concerned with procedure rather than conduct, but it now contains paragraphs on the secrecy of cabinet proceedings, collective responsibility, relationship with civil servants, acceptance of gifts and ministers' private interests, as well as the duty of accountability to Parliament. And then there's an extract from the Nolan Committee's first report where it says, QPM, Questions of Procedure for Ministers, has no particular constitutional status, but because it's issued by each Prime Minister to ministerial colleagues at the start of an administration or on their appointment to office, and any changes can only be authorised by the Prime Minister, it is in practice binding on all members of a government. And then it continues how it's grown organically over the years. So that would appear to be the origins of it. And then yes.
And that's exactly what I was trying to indicate in the report, was that although the codification has been quite recent, 20, 25 years, these were based on conventions and procedures which went back, I think, far beyond 1945, and therefore are of relevance to the considerations of the inquiry.
And then it was renamed the Ministerial Code, I think, in around 1997 under the
Prime
Blair
Minister
government.
Blair,
And then the current version of the Ministerial Code for the UK government is 2022. And you've explained there are separate codes in relation to Scotland, Wales and Northern Ireland. In your report, and we don't need to put it on screen, but it's internal pagination, page 4, you've explained that the UK Code has no statutory backing or form of enforcement, and the same, I think, is the position in relation to Scotland and Wales. But the Northern Ireland Code does have statutory backing and sets out a process for investigations. Do you know, or does Ms Salters know, why there's that difference between the approach taken in Wales, Scotland and England and the approach in Northern Ireland?
Well, Claire may want to answer the Northern Ireland question. I'd only say that as far as the rest of the UK is concerned, there's been considerable pressure over the years to have some statutory backing for the Ministerial Code, but that still isn't in existence at the moment. But if I may defer to Claire.
Absolutely.
The Ministerial Code in Northern Ireland was put on a statutory basis following the St Andrews Agreement in October 2006. The legislation that we put through after that put it on a statutory basis. The reason that was done is because the code there, as well as being the compact between ministers and the public, the standard that they would adhere to there, was also part of the agreement between the parties about how they would operate in what is an enforced coalition there. So key provisions of the code were essentially part of the St Andrews Agreement, and therefore, to give effect to the whole of the St Andrews Agreement, it was put on a statutory basis to confirm that and cement it in statute.
And then in relation to the rest of the UK, you mentioned there had been pressure over the years to put it on a statutory or more formal basis. Would it be right to understand from the fact that that hasn't happened, that there has been resistance on the part of successive governments to that?
There's been no great enthusiasm, I'd say, rather than resistance.
Could I add one other point? I think there's also the practical reality of legislative time, and if there is no great enthusiasm for this, there are always other things that are legislative priorities, so things like that tend to slip down, so that may explain.
How have the ministerial codes been formulated? We'll look at the text of the current one for the UK government in a moment, but do you know how they've been created and put together, and by whom?
So far as I know, drafts would have been prepared within the Cabinet Office and would have been made available to the Prime Minister and anyone else he wished to involve on the contents of the code.
And Ms Salters, in relation to Northern Ireland, do you know how that code was put together?
A combination of the Northern Ireland Office and the what was then the office of the First Minister, Deputy First Minister, now the Executive Office, their central secretariat team.
And in relation to Scotland and Wales, Lord Bishard, do you know how those codes have been formulated?
Well, no, I don't specifically. My suggestion would be that they had also been influenced by the Cabinet Office and by the Prime Minister. And I think Claire, or the sections on devolution within the report make clear that the UK government often has a disproportionate influence on what's going on in Wales and Scotland. And I suspect that's the case here.
And that particular theme is a theme we'll come back to when we explore issues relating to devolution. Can we then just look at the current code? Lawrence, it is an RLIT 0001738. So this is the current code for the UK government, Ministerial Code, Cabinet Office, May 2022. And we can see over the page a foreword by the then Prime Minister, Boris Johnson. Yep. We've then got an index on the next page. And we can see, I just want to identify the structure of the code. So matters of general principle, ministers and the government, ministers and appointments, ministers and their departments. Over the page, ministers and civil servants, ministers' constituency and party interests, ministers' private interests, ministers and the presentation of policy, and then next page, ministers and Parliament and then travel by ministers. And then we'll see at Annex A the 7 principles of public life, which I'll come back to. So that's the structure of the code. I'm not going to go through the vast majority of it, but that's for those who may wish to explore different aspects of it. But if we can just look at just 2 or 3 individual paragraphs, starting on page 6. We've got the heading Ministers of the Crown, and then on the left-hand side, General Principle. And then 1.1 says Ministers of the Crown are expected to maintain high standards of behaviour and to behave in a way that upholds the highest standards of propriety. And then paragraph 1.3 then says the Ministerial Code should be read against the background of the overarching duty on ministers to comply with the law and to protect the integrity of public life. They're expected to observe the 7 principles of public life set out at Annex A and the following principles of ministerial conduct. And then I just want to go through some of these and then ask you a handful of questions about them, Lord Bichard. So, first of all, the principle of collective responsibility applies to all government ministers. Could you just summarise for us briefly what the principle of collective responsibility is, Lord Bichard?
It's a good morning to do so, isn't it? I think normally the collective responsibility means that ministers in cabinet, Secretary of State and cabinet, should be able to discuss issues frankly and openly, and when they leave cabinet, they, whatever the decision, should take collective responsibility for that decision, even if in cabinet they've argued another way.
And then point B, ministers have a duty to Parliament to account and be held to account for the policies, decisions and actions of their departments and agencies. Perhaps self-explanatory, but I might want to unpick some of that in a little while. C, again, potentially topical, it is of paramount importance that ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity. Ministers who knowingly mislead Parliament will be expected to offer their resignation to the Prime Minister. Now, would it be right to understand that although there wasn't a code in this form in the 60s, 70s and 80s, there was the unpublished questions, the procedure for ministers, is the principle that's described in paragraph C here one that to all intents and purposes has always been part of the responsibility of ministers?
Yes, we refer in the report to the concept of ministerial responsibility, which is basically ministers, secretaries of state, always taking responsibility for everything that happens within their department and for the actions of their officials and their junior ministers. I think that's exactly what this is saying. It's a really important issue, this, because it doesn't just apply to ministers and their relationship to Parliament. It applies to civil servants and their relationship to ministers and therefore to Parliament. And that's the accountability chain which has always existed, but which, as I say, has been codified rather better in the last 25 years. The second C, 13C, ministers who knowingly mislead Parliament will be expected to offer their resignation. Again, as we say in the report, that has not always happened, and at the end of the day, it seems now to come down to the decision of the Prime Minister and whether or not they retain confidence in the Minister. The last point I'd make in emphasising the point you were making is that, of course, in the past, some ministers have felt it necessary, not many, to resign when things have gone wrong in their department. And as we say in the report, the most famous of these was Trickle Down, but that was back in the 1950s, when a minister resigned, although they knew nothing at all about, at the time, they'd known nothing at all about the issue. They felt that they should resign and famously said, if I can take credit for the good things that happen in the department, I should be held accountable for things when they go wrong.
And then the fourth subparagraph here, the principle of ministerial conduct. Ministers should be as open as possible with Parliament and the public refusing to provide information only when disclosure would not be in the public interest, which should be decided in accordance with the relevant statutes and the Freedom of Information Act 2000. Now, to what extent has that principle of being as open as possible with Parliament and the public, again, been a principle governing ministerial conduct going back for decades? Obviously, the Freedom of Information Act itself is only the last couple of decades.
Yeah, I mean, it certainly has been a principle, uncodified at the time. And I think the problem with this paragraph is it's difficult to be able to comment on the extent to which ministers have followed it, because if you don't know what you don't know, it's difficult to draw a conclusion, to make a judgment. But there's no doubt in my mind that Parliament expects ministers not just to provide the information they have, but to take reasonable steps to get the information they need to be able to be held accountable to Parliament.
It might be said that there's a degree of tension between the principle of openness and the principle of collective responsibility. And the inquiry certainly has heard evidence from some ministers to the effect that they thought the policy should be X, but the principle of collective responsibility required them to publicly state adherence to policy Y. Do you have any observations on that?
I think that's true, but we do operate a cabinet system. It is based upon collective responsibility. It is always possible for ministers who feel unable to take collective responsibility for a decision to resign. And there have been one or two examples of that thinking back over the years. And that's an important point, because when we talk about the Civil Service Code later, I think, the same applies there. There's a point to which you can go if you feel that you're being asked to sign up to something which is not in your view acceptable, then you have the right to resign, and I would say you should resign.
And then subparagraph E, ministers should similarly require civil servants who give evidence before parliamentary committees on their behalf and under their direction to be as helpful as possible in providing accurate, truthful and full information in accordance with the duties and responsibilities of civil servants as set out in the Civil Service Code. And perhaps I'll pick that up when we look at the Civil Service Code. And then the remaining subparagraphs deal with potentials for conflict of interest, issues about gifts and hospitality, the distinction between the role as minister and constituency MP, and the use of government resources or non-use of government resources for party political purposes, and then the political impartiality of the civil service, which again I'll pick up when we look at the civil service. And then if we can look at paragraph 1.4, because this turns then to the question of enforcement of the Ministerial Code. 1.4 says this: it's not the role of the Cabinet Secretary or other officials to enforce the code. The Prime Minister's independent advisor has a role set out in terms of reference published by the Prime Minister in advising the Prime Minister and ministers about adherence to the code. Ministers are expected to provide the independent advisor with all information reasonably necessary for the discharge of his role. Investigations into adherence to the Ministerial Code may occur, and then A is if there's an allegation about a breach of the code and the Prime Minister, having consulted the Cabinet Secretary, feels it warrants further investigation. He may ask the Cabinet Office to investigate the facts of the case or refer the matter to the independent advisor on ministers' interests. And then B, where the independent advisor believes that an alleged breach of the code warrants further investigation and that matter has not already been referred to him, he may initiate an investigation. Before doing so, the independent advisor will consult the Prime Minister, who will normally give his consent. However, where there are public interest reasons for doing so, the Prime Minister may raise concerns about a proposed investigation such that the independent advisor does not proceed. And then just paragraph 1.6, before I ask you a little about this. 1.6 says, ministers are personally responsible for deciding how to act and conduct themselves in the light of the code and for justifying their actions and conduct to Parliament and the public. However, ministers only remain in office for so long as they retain the confidence of the Prime Minister. He, should now of course be she, is the ultimate judge of the standards of behaviour expected of a minister and the appropriate consequences of a breach of those standards. So if we can just go back to the previous page, Lawrence. is it right to understand from this that ultimately adherence to the ministerial code or enforcement of the ministerial code lies in the hands essentially of the Prime Minister?
Absolutely, and I think to underline that, at the beginning of 1.4, it's not the role of the Cabinet Secretary or other officials to enforce the code, nor should it be, because in a democracy, officials should not be controlling democratically elected representatives. So it's not the Cabinet Secretary's responsibility. It is, at the end of the day, the Prime Minister's responsibility, and the Prime Minister will make a judgment on reports that he receives. And we, I think, mentioned in the report that there was a recent case involving the then Home Secretary who'd been accused of bullying and harassment in the department, who the independent advisor found guilty of that, but the Prime Minister decided not to ask her to resign, as a result of which the independent advisor resigned. That was Sir Alex Allen. And that, I think, is an indication of the importance of the Prime Minister in all of this.
For how long has there been, if we leave aside the current position, for how long has there been someone occupying the role of independent advisor?
I don't think I can answer that, I'm sorry. I mean, for some considerable time, Alex Allen was the independent advisor at the time of the Home Secretary case. He'd certainly been in post for, I think, 10 years. And I can't remember if there was someone before him.
I'm sure we can.
Of course, the
find that out.
post now is vacant.
Yes, that was the second point I was going to ask. So there is currently no independent advisor.
No, there isn't.
So in terms of enforcement of compliance with the ministerial code, currently it's really solely down to the Prime Minister.
Yeah, it's entirely down to the Prime Minister, who I'm sure will be taking advice on a relevant issue from officials, but it's down to the Prime Minister.
We touched on collective responsibility, and that's set out in a little more detail on the next page. No, sorry, 2 pages on Lawrence, page 9. I'm not going to read it out, but we can see that paragraph 2.1 describes the principle of collective responsibility, which you summarised for us. Could we go on to page 10, please, Lawrence? It's just a point towards the bottom of the page I wanted to pick up because it's an issue that's arisen in the course of inquiry hearings. So we have the heading Cabinet Documents. 2.7, Ministers relinquishing office should hand back to their department any Cabinet documents and or other departmental papers in their possession. And then 2.8, on a change of government, the Cabinet Secretary on behalf of the outgoing Prime Minister issues special instructions about the disposal of Cabinet papers of the outgoing administration. And then 2.9, access by former ministers to official papers. By convention and at the government's discretion, former ministers are allowed reasonable access to the papers of the period when they were in office. With the exception of former Prime Ministers, access is limited to former ministers personally. And then there's a further description in relation to that. Now, a number of ministers have told this inquiry that they did not have access to matters relating to the advice that had been given or decisions that had been taken by their predecessors. Do you have any observations or reflections on that and on the extent to which that may hamper decision making?
They don't have access to either papers relevant to their predecessors or indeed to the advice which civil servants gave to their predecessors. They do have access to papers which they saw or were party to if they need to. I think it says reasonably necessary. So for an inquiry like this, or for allegations that might be made by the media, then ministers are allowed reasonable access in order to counter those allegations or to advise an inquiry like this to the best of their ability. But ministers do not have access to the advice or the decision-making process of their predecessors.
And from your perspective, is that a good or bad thing?
Well, I think it would be quite difficult if you had a change of government for an incoming government to have access to all the advice that was given to a predecessor government or the decision-making process. For example, it would be extremely difficult if it was seen that a civil servant gave advice to a former Secretary of State which ran counter to what the incoming government wanted to do. You can say, well, they were acting, the civil servant was acting in accordance with the Civil Service Code. I don't think civil servants would feel very comfortable if they knew that the advice they were given was going to be accessed by an incoming government of a different colour. So I can understand why this is the convention. And I think somehow permanent secretaries, senior civil servants and ministers of the day find a way of not circumventing that, but of ensuring that if there are lessons to be learned from a previous period, then they are learned. But they would not be learned in direct relationship to a Secretary of State or to a civil servant in a previous administration.
And is a civil servant briefing a new minister in a different administration? Is a civil servant in that briefing entitled to say anything about the former minister's stance that wasn't a matter of public parliamentary record? Can they say, well, this has been an issue that's been under consideration by successive administrations. You know, your predecessor, asked the following questions and had the following concerns.
No, I don't think there's a code which sets that out. As a former permanent secretary, I would not have been comfortable saying that. What I might have said is, well, there are some lessons that perhaps we need to learn from ways in which this has been managed, and I think we should avoid doing A, B, and C. And my Secretary of State might give me an old-fashioned look, knowing that I was actually talking about what might have happened before, but I wouldn't have directly attributed that to a previous minister or a previous Secretary of State.
And
you can see that if that happened, then the current, if I can use that term, Secretary of State will be able to go out and say, well, you know, I know that they were given this advice, they didn't take it, it's outrageous. So I think we work on a basis that you don't attribute, if you're a permanent secretary or senior official, you don't attribute it directly to a former minister.
so would it be right to understand the concern is as to the political capital that could be made by the new government? Ms Salters, do you have any observations on this issue?
So I would it's exactly that point. It's to avoid the incoming administration making political capital about their opponent's decision-making process, rather than a secrecy about the information. So as Lord Bishard said, you wouldn't share the precise documents you put up, but in your initial briefing of an incoming administration, you would say, on this particular subject, these are the issues that need to be focused on in the short term, looking at the manifesto of the incoming government. Each government department would have been scrutinising all the manifestos to make sure that they were ready to deliver what the incoming government wanted to do, and would also have an idea of what the urgent issues were on each particular subject, and be able to flag those up for incoming ministers who would need to take decisions on them going forward. So there can be recycling of a lot of information that was in the advice, but it wouldn't necessarily be the advice, the exact document that would have gone previously.
You see, the objective of all of this is to ensure that at any particular time, the exchange between a permanent secretary or senior officials and the Secretary of State is completely frank and open, and that both sides can trust each other not to make that public. And if that breaks down, then actually our system of government breaks down, because ministers are not being given the best advice at a particular time. Now, I had the experience of working for 2 years as permanent secretary for the Conservative government, swiftly followed by 5 years working for a Labour government. Had the Labour government been able to access the advice I'd given to the Conservative government, it would have made my position quite uncomfortable. And it would have, more to the point, if that was possible, then the advice that I gave to the incoming Labour Secretary of State, I would have always been just wondering how far I could go, because this might be put in the public domain. I don't think government works well in that situation. But as I say, it's important to say, if I felt that there were lessons to be learned from history of policy or delivery, then I'd try and find a way of ensuring that the present government had access to that through my advice.
Could I add
Yes.
one point to that? I think it's maybe you were speaking euphemistically. It's not about the discomfort of the civil servant. It's about being able to serve the government of the day fully and wholly, and deliver their policies, and throw yourself into that. So it's not about personal protection for the civil servant. While you're serving the Conservative government, you were wholly delivering on their policies. When there's a change of government, your job is wholly to deliver on their policies. So it's being able to make that switch and build the relationship of trust that you were there to deliver what they're asking you to, rather than being loyal to a former regime. It is a neutral position. I'm sure we'll come on to talk about that later.
It's absolutely right, and the way I would put it to incoming Secretaries of State or Ministers, I will aggressively, enthusiastically pursue and try and implement your policies. I will advise you to the best of my ability. I will speak truth to you when I need to. You need to understand that if there were a different government here, I would do the same with them. And that's the definition of my neutrality.
And then in terms of the relationship between ministers and civil servants, that's addressed further in section 5 of the Ministerial Code. If we can go to page 17, please. We have the heading Ministers and Civil Servants. 5.1, ministers must uphold the political impartiality of the civil service, not ask civil servants to act in any way which would conflict with the Civil Service Code and the requirements of the Constitutional Reform and Governance Act 2010, which we'll look at shortly. And then 5.2, ministers have a duty to give fair consideration and due weight to informed and impartial advice from civil servants, as well as to other considerations and advice in reaching policy decisions, and should have regard to the principles of scientific advice to government. I'm going to come back to some of the issues about how ministers take decisions at a later stage, but I just flagged that up so that we don't need to return to this document. And then if we go to, well, I don't think we need to turn to it, but the 7 principles of public life, also referred to as the Nolan Principles, are an Annex A to this document. But before we look at those, I just want to look briefly at the Nolan Committee report on standards in public life, the first report, which gave rise to those principles. So if we could have, please, Lawrence, RLIT 00001795. So we can see it's the first report of the Committee on Standards in Public Life, chaired by Lord Nolan. If we just pick it up, first of all, at page, I think it's probably page 9, Lawrence. Yes, so paragraph 19, very high standards of conduct are rightly expected from ministers and civil servants. Paragraph 20, a code of conduct for civil servants has recently been announced. So just pausing there, we'll come on to this, but the origin of there being a civil service code was, is this right, the Nolan report? Is that correct?
Yes, absolutely.
And then the existing guidance for ministers is sound, but needs to be drawn together into a clear set of principles. And then if we go to paragraph 23, for both ministers and civil servants, the system should be made more open to public scrutiny than at present. 24, there is insufficient monitoring of the effectiveness of similar arrangements for more junior civil servants, and these should be reviewed. And then paragraph 27, if we go a little further down the page, more needs to be done to ensure that all civil servants remain aware of the standards of conduct required in the public sector. And then if we go to, I think it's page 14, please, Lawrence. We have a recommendation 13. The Prime Minister should put in hand the production of a document drawing out from QPM, Questions of Procedure for Ministers, the ethical principles and rules which it contains to form a freestanding code of conduct or a separate section within a new QPM. So would it be right to understand that it's in the Nolan report that we see, first of all, the formal articulation of the 7 principles of public life? Is that right?
Yes.
We see the recommendation that there should be a formal civil service code.
Yes.
And we see the recommendation that the questions of procedure for ministers should be reformulated effectively into a ministerial code.
And you also see the indication that the Civil Service Commission should have a role in dealing with any issues where any examples of a civil servant feeling that they were being asked to breach the code, and you may well want to come onto that in your questioning. So, as we say in the report, the Nolan Principles are a pivotal moment because it not only informed the codes that we've been talking about, but it informs the expectations of anyone who works in the public service. And that's the difference between Nolan and the ministerial codes and the civil service codes. Civil service code relates to civil servants. The Nolan principles relate to anyone in public life, whether they are ministers, civil servants, local government officers, NHS staff, outsourcing agencies. All of them are expected to work in accordance with the Nolan Principles. And if you look now at, which I fortunately no longer have to do, applications for jobs in the public service, they will nearly always refer to the Nolan Principles as being the central code of behaviour for successful candidates.
And if we look at the Nolan Principles, or the 7 Principles of Public Life, Lawrence, we have them at RLIT 00001741. And we see they're published 31st of May 1995. You say in the report that although this was the first time they were formally published, these principles had long underpinned the spirit of public service in this country. So is that right? These were not new. What was new was drawing them together, publishing them, and therefore creating a public expectation of compliance. Would that be right?
Yeah, I mean, we need to remember that Nolan was set up because there were concerns about behaviour in and around government. And you're quite right to say that these were based upon conventions, but clearly the conventions hadn't been working as well as the public, the press, and actually government wanted. So Nolan was an important moment in defining, in articulating what those conventions should mean.
And if we go to page 3, we see the principles themselves. And as you've just observed, Lord Bishard, the first paragraph explains that this applies to anyone who works as a public office holder. And then we have the principles. Selflessness, holders of public integrity should act solely in terms of the public interest. Integrity, holders of public office must avoid placing themselves under any obligation to people or organisations that might try inappropriately to influence them in their work. They should not act or take decisions in order to gain influential or other material benefits for themselves, their family or their friends. They must declare and resolve any interests and relationships. Objectivity, holders of public office must act and take decisions impartially, fairly and on merit, using the best evidence and without discrimination or bias. Accountability, holders of public office should act and take decisions in an open and transparent manner. Information should not be withheld from the public unless there are clear and lawful reasons for doing so. Honesty, holders of public office should be truthful. And then leadership, holders of public office should exhibit these principles in their own behaviour and treat others with respect. They should actively promote and robustly support the principles and challenge poor behaviour whenever it occurs. Now, those are broad principles. If focusing just for a moment on ministers, if responsibility for enforcement effectively rests with the Prime Minister, does that mean that in practice it's the Prime Minister's understanding of what's meant by, or what's required by, selflessness or integrity or objectivity or honesty that governs the scope of the principles? Or is there some broader objective understanding of what these principles in practice require?
Well, I think the Prime Minister has to take into account, when he's got the facts and advice on a particular issue, whether or not the individual has fallen foul of the principles of public life or other issues within the Ministerial Code, because the Ministerial Code goes beyond the Nolan Principles, and he must then come to a conclusion as to whether that person still has his or her confidence and whether or not he or she will ask them to resign. But as we say in the report, the Nolan Principles have become, if you like, the framework within which the Civil Service Code, the Ministerial Code, and general standards of behaviour in public service are now framed.
And to what extent is there any openness about the process of investigating a potential breach of the Ministerial Code or a breach of the Nolan Principles in relation to ministers? So, I mean, there've obviously been recently various well-documented issues in the media, but leaving those aside, more generally, how does a potential breach of the Ministerial Code usually come to the attention of the Prime Minister, and is there then a process for others to be aware of and involved in the investigation?
Well, the Prime Minister themselves might feel that there's an issue of concern which they wanted to see looked at. They might have that drawn to their attention by other ministers or by the Cabinet Secretary. They might have it drawn to their attention by the independent advisor, and the independent advisor might feel the issue is important enough for them to carry out an investigation, in which case they would recommend that to the Prime Minister, and if the Prime Minister agreed, then they would carry out an investigation. Now, I think the first question in that batch that you asked was how open is the process of the investigation? Not very open. But then it's quite difficult to see how it could be entirely open without prejudicing the process itself. The independent advisor is appointed on the basis that they have the confidence not just of the Prime Minister but of Parliament and indeed the public, and therefore they, in the same way as the police would go about an investigation, the process would not be in the public domain, so the advisor would go about the process in the same way. Their reports, however, would normally be published. The Prime Minister would agree to it being published. The independent advisor doesn't, I think, have the power to publish the report themselves without the Prime Minister's approval.
And then if we can go, please, next to the issue of civil servants. In the report at page 5, and perhaps we'll just put this on screen, so it's EXPG 5047. Right. And if we could go, please, to page 14, I think. It should be internal page 9, but I think it's electronic 14. Yeah, no, that's the wrong page. Can you go back 3 pages, please? My apologies. Yes. So bottom of the page under the heading, the Civil Service Code. The report says the Civil Service Code was first issued in 2010 by the Minister for the Civil Service. Now, that's not entirely correct, and I think Lord Bishadi wanted to correct that.
Yes, I should have said in the report, and I apologise, the Civil Service Code was first issued in 2010 as a statutory code. under the auspices of the Constitutional Reform and Governance Act 2010. Before that, there was a civil service code, similar in many respects, but you may want to go on and look at that. But the first statutory code was in 2010.
And was it in 2010 that the Civil Service Commission was established?
No, Civil Service Commission existed before that, but obviously the Act and the Code changed some of the responsibilities of the Commission. You may want to come on to that.
Can I just add that the Civil Service Commission was put on a statutory basis for the first time in the Constitution Reform and Governance Act 2010, but it had existed, the commissioners had existed for decades before that. I should know they may even have gone all the way back to the Northcote Trevelyan reforms of the 1850s. They're a long-standing institution, but they didn't have the force of statute until 2010.
And the 2010 Act imposed a statutory duty on the Minister for the Civil Service to publish a code of conduct for the civil service, other than, I think, in relation to Northern Ireland.
Because that's a separate civil service.
And then if we just look at RLIT 301737, please. This is a report from a select committee of the House of Lords, the Select Committee on the Constitution, published in 2012. It's called The Accountability of Civil Servants. I just wanted to pick up a couple of matters in here. First of all, if we go to page 8, we can see there that the section on ministerial responsibility. A fundamental principle of the British system of government is that civil servants are fully accountable to ministers, and ministers are fully accountable to Parliament for all their and their department's actions and omissions. This principle is often referred to as the Convention of Individual Ministerial Responsibility. And then it goes on to give the example that you referred to, Lord Bishard, of the Crickle Down episode. And indeed, we have the quote there, it might just be worth reading it, from the then Minister of Agriculture, where he says this: I, as Minister, must accept full responsibility to Parliament for any mistakes and inefficiency of officials in my department, just as when my officials bring off any successes on my behalf, I take full credit for them. Any departure from this long-established rule is bound to bring the civil service right into the political arena, and that we should all, on both sides of the House, deprecate most vigorously. That's the quote that you referred to, I think, earlier, Lord Bishard. And then, if we go to the next page, paragraph 5, it refers there to 1997, both Houses of Parliament agreeing resolutions on ministerial accountability, and it's observed that the adoption of the resolutions was significant in changing the doctrine of ministerial responsibility to Parliament from an unwritten constitutional convention into a clear parliamentary rule which can be modified only by Parliament. There's then a discussion about whether the principle needs re-examining, and if we just go over the page, we see the conclusion of this committee. At paragraph 12, we conclude that the convention that ministers are constitutionally responsible for all aspects of their department's business is an essential principle underlying the arrangements that enable Parliament properly to perform its function of holding the government to account. The convention is clear, straightforward, and leaves no gaps. Now that's a report from 2012. Is it right to understand that remains the position? This convention of ministerial responsibility is still an accepted convention, albeit your report tells us that, for example, there are occasions more recently where criticisms of decision-making have led to resignations by civil servants rather than ministers.
I think the convention is still in existence. It is clear. Whether it's straightforward and leaves no gaps, I think is another question, simply because the point that's made elsewhere in this report, the complexity of government is such that some argue, and I don't just mean ministers, I mean academics and others, that it is unreasonable to hold a minister responsible for something that happens far away from London, maybe, because a civil servant has behaved inappropriately or taken the wrong decision. And so although the convention is absolutely clear, I think people have been more prepared to listen to mitigation. And as I said right at the beginning of our exchanges, at the end of the day, it comes down to whether Parliament retains confidence in that minister, whether the Prime Minister retains confidence in that minister. What I would say is that although government has become so much more complex, and therefore one might, I'm not saying I do, have some sympathy with a minister who's caught unaware by something that happened well outside of London, and maybe in an issue decided by junior civil servants. If the minister becomes aware of an issue and then doesn't deal with it or doesn't take action to mitigate, to minimise the chance of it happening again, then I think it is a more serious issue and mitigation is more difficult, and you are more likely to see Parliament and the Prime Minister taking a different view.
And then if we go to page 14 and just pick up on a passage about the civil service before we look at the Civil Service Code. Paragraph 28 says this, in the words of the Select Committee: we recognise the importance of an impartial, objective civil service appointed on merit and able to serve the government of the day whilst retaining the capacity to serve future governments of differing political complexions with equal commitment. The ability of the civil service to perform this function is one of the major strengths of the UK Constitution, enabling the smooth transition from one government to another in accordance with the wishes of the electorate while maintaining stability and continuity. And then this: the civil service attributes of integrity, honesty, objectivity and impartiality form the bedrock upon which the permanent civil service is built. While these values were not enshrined in statute until the Constitutional Reform and Governments Act 2010, the civil service has been firmly based on them for at least the last 160 years, since the Northcote-Trevelyan report. We fully support these principles, both as constitutional norms and as statute law. So we'll look at what the codes say about integrity, honesty, objectivity and impartiality. But as I read this and your report, perhaps the key point is, although the codes themselves don't come into existence until the second half of the 1990s, those were the principles and values that civil servants were expected to adhere to for decades. Is that right?
Exactly the point we try and get across in our report. You know, that, as I said a couple of times already, you may only recently have had the codes, you've had the conventions for a very long time. We have a democratic system which is different to other democratic systems. If you look at the American system, for example, they do not have an objective, impartial set of civil servants, which is why it takes an incoming president about 12 months to get the machinery in place to enable them to govern. That isn't what we try and do. We try and ensure that you can move, as I did, from advising one government to another. But for that to happen, it's important that these, what are sometimes called eternal verities, are respected.
You referred a few moments ago to, I think, the Northcote-Trevelyan report. As I understand it, but this is really a very limited knowledge on my part, that's a reference to a report produced in the 1850s by, I think it was a then Minister, Stafford Northcote, and C.E. Trevelyan, then Permanent Secretary at the Treasury. That's regarded as a founding document of the British Civil Service.
Yes, it was initially set up as a commission or as a project to look at the efficiency of the civil service. There was considered to be a problem with the quality of individuals in there, and their core recommendation was that it was essential that people should be selected on merit through an independent process, so that you could have a guarantee of competence, basically, and then the principles of objectivity and impartiality were layered on top of that. So once you've got someone competent, you want them to be able to serve both sets of administrations.
And then if we just look at the code itself, first of all, in terms of the 1996 code, which, as I understand it, was the first written civil service code. If we go to RLIT 301796, this is another House of Commons Library Research paper. This is from 1997. Lawrence, can we go to, I think it's page 47. Oh, can we go to the previous page, sorry. So I just want to pick it up, the paragraph before the heading Civil Service Code. Thank you, that's perfect. So the new code came into force from the 1st of January 1996. And then it says the Armstrong Memorandum has therefore been superseded by the code. And can you just tell us what the Armstrong Memorandum was?
Sir Robert Armstrong, then Lord Armstrong, now deceased, was concerned early in the 1990s about some issues that had arisen, one being, for example, the Clive Ponting affair, and wanted to make clearer when civil servants had a responsibility to be open and what were the limitations on that responsibility. So he produced the memorandum, the procedural memorandum, which was then superseded by the Ministerial Code in 1996, which was then updated and became a statutory code in 2010.
And then in terms of its content, we can see that set out, starting towards the bottom of the page. I'm not going to read through all of it, but we can see paragraph 1, the constitutional and practical role of the civil service is with integrity, honesty, impartiality and objectivity to assist the duly constituted government of whatever political complexion in formulating policies of the government, carrying out decisions of the government and in administering public services for which the government is responsible. And so we've got those 4 values there, integrity, honesty, impartiality and objectivity, which I think you've told us in your report were sometimes described as the eternal verities.
Yes, you have. And the only difference, or the main difference between these and the Nolan Principles is impartiality, because clearly that is an important part of we've been discussing it, important part of the civil servant's responsibility is to be impartial, so that they can serve governments of different colour. The 1996 code refers to impartiality. The 2010 code refers to impartiality, but also to political impartiality, so it develops that.
And if we just look at the bottom of the next page, and before I then pick it up with the current version of the code, so paragraph 6 at the bottom of the page, civil servants should endeavour to deal with the affairs of the public sympathetically, efficiently, promptly, and without bias or maladministration. And so that's the 1996 code. The full text is set out on in this document for those who would like to consider it. But I'm going to just ask you to turn to the current version of the code, and then I have a handful of questions in relation to that. So we have that at RLIT 000177, I hope. Civil Service Code, so we can see now it's in its statutory form, and this is a version updated as at March 2015. My understanding is that this is the current version. It seems to be the current version as published on the government website. If we turn to page 3. Yes. So we've then got those 4 core values identified: integrity, honesty, objectivity and impartiality, summarised there. And if we just go down the page, I just want to look and see what the code says about those individual values. So under the heading integrity, you must fulfil your duties and obligations responsibly, over the page. Always act in a way that's professional and that deserves and retains the confidence of all those with whom you have dealings. Carry out your fiduciary obligations responsibly, that is, make sure public money and other resources are used properly and efficiently. Deal with the public and their affairs fairly, efficiently, promptly, effectively and sensitively to the best of your ability. Ensure you have ministerial authorisation for any contact with the media. Keep accurate official records and handle information as openly as possible within the legal framework. Comply with the law and uphold the administration of justice. and then there's a description of things that must not be done. If we then go to honesty, you must set out the facts and relevant issues truthfully and correct any errors as soon as possible. Use resources only for the authorised public purposes for which they're provided, and then you must not deceive or knowingly mislead ministers, Parliament or others, or be influenced by improper pressures from others or the prospect of personal gain. And then objectivity, you must provide information and advice, including advice to ministers, on the basis of the evidence and accurately present the options and facts. Take decisions on the merits of the case. Take due account of expert and professional advice. You must not ignore inconvenient facts or relevant considerations when providing advice or making decisions. Frustrate the implementation of policies once decisions are taken by declining to take or abstaining from action which flows from those decisions. And then we see the heading of impartiality and political impartiality, as you've just alluded to. Impartiality, you must carry out your responsibilities in a way that's fair, just and equitable and reflects the civil service commitment to equality and diversity. And then in relation to political impartiality, you must serve the government, whatever its political persuasion, to the best of your ability in a way which maintains political impartiality and is in line with the requirements of this code, no matter what your own political beliefs are. And it continues. I haven't read out everything, but I hope that gives a sufficient account for the benefit of those listening of some of the principal requirements. Other than the distinction between impartiality and political impartiality, is anything in what's set out here new in 2010, or does this reflect what civil servants for decades would and should have understood with their obligations?
I think mostly it reflects previous conventions. I think there are some changes of emphasis. There are some explanations of those values which are not always given as much attention as others. For example, under integrity, civil servants should deal with the public and their affairs fairly, efficiently, promptly, effectively and sensitively to the best of their ability. And I think sometimes the emphasis is very much placed upon what's happening within the government system and the need for probity and propriety and all those other things that are so important. But certainly I was always wanting to stress the importance of dealing with, whether you call them clients, customers, citizens, or whatever, dealing with people sympathetically, sensitively, and efficiently. So I would perhaps underline that as one of those paragraphs. It doesn't always get as much attention as it should. And I think that there is, I think, a debate to be had about how far you go in not deceiving or knowingly mislead ministers and Parliament. For example, I don't think many people were set out to knowingly mislead ministers, but there are occasions when you might perhaps wonder whether with some further information you might be in a better position to brief a minister. Do you actually set out and go out and get that information? And if you don't, is that tantamount to misleading or deceiving a minister because you haven't put the full facts before them? This is when you get into some quite nuanced decisions. So this is not always as straightforward or as easy as it seems, but I just draw out those two as examples of that.
And then if I can just, if we turn over to the next page and just finish looking at this document perhaps before we break. So under the heading Rights and Responsibilities, your department or agency has a duty to make you aware of this code and its values. If you believe that you're being required to act in a way which conflicts with this code, your department or agency must consider your concern and make sure you're not penalised for raising it. And then if you have a concern, start by talking to your line manager and so on. And then if you become aware of actions by others which you believe conflict with this code, you should report this to your line manager or someone else in your line management chain. Alternatively, you may wish to seek advice from your nominated officer. You should report evidence of criminal or unlawful activity to the police or other appropriate regulatory authorities. And then the next paragraph, if you've raised the matter in accordance with the relevant procedures and do not receive what you consider to be a reasonable response, you may report the matter to the Civil Service Commission the Commission will also consider taking a complaint direct. Now, what I want to do is pick up, perhaps after the break, given the time, the role of the Civil Service Commission and what civil servants are expected to do if they have concerns either about other civil servants or indeed about ministers. So,
Okay, well, I won't comment on that, but I think it's important to say that in my experience, civil servants do receive a copy of the code on appointment and sometimes on changes of administration, so that they are clear what their responsibilities are.
thank you. So is that a convenient moment to break? Because I won't conclude my questions on this issue within a couple of minutes. A few more questions on this, and then I want to move to the next section of the report on public health.
Yes, well, we'll take a break now, as you suggest, and come back at 10 to 12. So 10 to 12.
Thank you, sir.